No, I haven't turned here.
Well, he should be there shortly, and he may be somewhere else at the facility.
Okay.
We're not going to go on record until he gets here or there.
Yeah, yeah.
Dan? Dan, you're muted. Go ahead and unmute yourself. I can see you, but I can't hear anything.
Like, as the commercial says, can you hear me now?
I can hear you just fine. Loud and clear, loud and clear.
Okay.
It was one of those 2-week periods. Sorry to load you up with too much on your plate there this morning.
No, I already ready to go and everything. Had an just.
Did you get my text?
I did, yeah. I did, sir. Just give me 1 second. I'm gonna mute just for a second here.
Sure, go ahead. See who he's gonna take first.
So morning, Judge. This is, we on the record, Judge?
We're on record, go ahead.
Thank you, Your Honor. So this is Jeremy Brissett. He's the first case on the arraignment calendar this morning at 8:30. The matter comes before the court for arraignment on a criminal trespass in the first degree. I've had an opportunity to discuss the matter with Mr. Brissett, and we've discussed what an arraignment is. He would like to proceed this morning by way of waiving the arraignment and entering a straight plea of guilty to the reduced charge of criminal trespass in the second degree. I've gone over the statement of defendant on plea of guilty with him, which I prepared electronically, but I described it for him. He does understand the rights you give up by pleading guilty, and I would ask Your Honor to inquire.
Mr. Brissett, good morning. For the record, your name is Jeremy Thomas Brissett.
Yes, yes.
You disagree with anything at all your attorney just said?
The what?
I'm looking at a statement of defendant on plea of guilty to 1 count of criminal trespass in the second degree, amended down from a original charge of first degree. Plea form tells me you're 45 years of age. Any issues at all reading, understanding the plea process?
No, sir.
Have you gone over it with your attorney?
Yeah.
And you're willing to waive formal arraignment and proceed to a disposition?
Yes, sir.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal. There could be a sentencing, which could be up to the maximum of 90 days and or $1,000, regardless of what's recommended. You realize that?
Yes, sir.
That in mind is to 1 count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on December 20th, 2021. How do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. The recommended sentence is 90 days, but all suspended on the condition that you have law-abiding behavior, stay out of trouble. I take it there's no recommendation for any fine.
No, Judge.
Nothing to add, Your Honor.
Mr. Haverco, anything you'd like to add?
Nothing to add. You know, he just realizes he was held in custody because of his, challenges in getting to court, and just wants to take care of this matter today and get it behind him and just kind of move on.
Mr. Brissett, anything you'd like to tell me?
No, sir.
I'm going to follow the recommendation. 90 days in jail, all suspended for a year on the condition you have law-abiding behavior. I don't like to keep people in jail, but after 3 times promising to appear, then 3 times failing, I didn't feel I had any choice. Now the conditions of the 90 days suspended are just stay out of trouble. You know, if you're not welcome someplace, don't go there. Stay out of trouble. And
Yes, sir.
you won't be talking to me again.
Yes, sir.
Any questions?
No, sir.
Signing the statement, and when I get go back to the dashboard here in a minute.
Mhm.
Mr. Brissett, I'm reviewing, and I will sign the judgment and sentence. You'll get a copy of that, as will your attorney. Unless you have some other holds on you, you'll be released today on this hold. You take care of yourself, stay out of trouble, and good luck to you.
Yes, sir. Thank you.
Thank you, Your Honor.
Thank you, Mr. Havergo. Take care.
So then we have, he's gonna be released. Okay. And give me 1 second. Good morning, Your Honor. This is Ms. Stephanie Panowski.
Good
Am I
morning.
saying that right?
Poinowski, yes.
Poinowski,
Yes.
okay, Poinowski. And she is comes on before the court on matters 2, 3, and 4 on the arraignment calendar today. I had a chance to speak with her about all of her cases prior to today, and we reviewed the police reports and talked about everything. And we also talked about what an arraignment is. And based on the city's offer, she would like to waive formal arraignment. And she would like to take care of these matters today by entering pleas. I prepared a statement of intent on plea of guilty, which I have reviewed with her. And she proposes to plead guilty to theft on the case ending in 730. Also pleading guilty to theft on the case ending in 360. And then as part of the agreement, then the city would move to dismiss the case ending in 324, which has 2 counts, theft third and obstructing a law enforcement officer.
That's all correct, Your Honor.
Good morning, ma'am. For the record, is your name Stephanie Connie Polanowski?
Yes, sir.
You disagree with all of anything Mr. Havergo just said?
I'm sorry, could you repeat that?
Do you disagree with anything your attorney just said?
No, sir.
Sounds like you're willing to proceed to a disposition of the case, waiving formal arraignment so you can take care of the matter today.
Yes, sir.
Is that correct?
Yes, sir.
I'm reviewing a statement of defendant on plea of guilty to a first count of theft in the 3rd degree alleged to have occurred on September 15th. This plea to another charge of theft in the 3rd degree alleged to have occurred on April 20th, 2022. In return for that, the city is moving to dismiss the ticket ending in 324, 2 counts obstructing and theft. Is that correct?
Yes. Yes, sir.
Plea form tells me you're 34 years of age. Any difficulty understanding the process?
No, sir.
And you've gone over the plea form with your attorney?
Yes, sir.
If I accept the pleas, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum, which would be 364 days in jail and or a $5,000 fine, regardless of what's recommended. You realize that.
Yes, sir.
With that in mind, as to one count of theft in the third degree alleged to have occurred within the city of Yelm on September 15th, 2020, and a second count of theft in the third degree alleged to have occurred within the city of Yelm on April 20th, 2022. How do you plead guilty or not guilty?
Guilty.
Make that plea of your own free will.
Yes, I plead guilty.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
Find the plea to be pleased to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. The recommendation is 364 days in jail on each charge, all suspended on the condition you have law-abiding behavior. Is there
Okay.
anything you'd like to tell me?
I'm sorry? Is there anything I'd like to tell you? No, sir.
Julie, anything further at all? That's
Nothing further, Your Honor. It's agreed recommendation.
Mr. Abaco, anything further?
Nothing to add, Your Honor. It's an agreed recommendation. Would ask Your Honor to follow it.
Ms. Owenowski, I'm going to follow the recommendation, 364 on each, suspended on each. Condition is law-abiding behavior. And, I don't like to hold people in jail, but after all the non-appearances and the reoffenses, I just
I understand.
had any choice at all. Now, you've got 2 days left and less than 2 years in jail, suspended. It's important you stay out of trouble and just leave that time suspended. Any questions at all?
No questions, and I thank you.
Now, you will be released today. If there's no other holds on you, this hold will certainly be lifted before the morning's over, okay?
Okay, thank you, sir.
I'm going to wish you the best of luck, Ms. Hohenowski. You take care of yourself, okay?
Thank you. Thank you. Thank you.
Thank you, Your Honor. You're welcome.
This came up, Donnie. When it's at the same signature, do I need to just save this? Please sign. Start again. Start again. That was weird. Just not. Without saving, this actually includes the document. Let's see.
Yeah, if you get to.
Please continue. Okay, now try it again. Try this. Strange.
I'm gonna close it up. I see what's on my end.
It's been approved.
Yeah. I think we might do- what's that? Maybe this one. Yeah. So we'll click on it.
There you go. Double click. Strange.
So now try to.
Let's see what's happening.
What do I just stand now? Just stand there for a second.
You are currently editing it. I think that may have done it. Holy cow. Check this box. Now, we're back to. From there, we'll go to the jails. Well, that was a new one.
Yeah, I haven't seen that before.
Morning, Your Honor. This is Travis Keena. He comes on before the court for an arraignment on 3 different cases. Disorderly conduct, malicious mischief third case, and a criminal trespass first degree case. And I had an opportunity to speak with Mr. Keena yesterday and review the police reports on these cases. And we talked about what an arraignment is. These cases come before the court for an arraignment. He'd like to take advantage of the city's offer. And so I prepared a statement of defendant on plea of guilty. It would be his intention to waive arraignment and plead guilty to the case ending in 713. That's malicious mischief. Also plead guilty to the case ending in 715, but with a reduction to criminal trespass in the second degree as opposed to the original charge of criminal trespass in the first degree. And then upon the court's acceptance of those pleas, then the city, as part of the agreement, would move to dismiss the case ending in 799.
That would be the disorderly conduct.
That's correct, Judge.
Good morning, sir. For the record, is your name Travis, middle initial W, Keena?
Yes. You need to answer if he's talking to you. Yeah.
Are you Travis Keena?
Yeah.
Mr. Keena, have you gone over the statement of defendant on plea of guilty with Mr. Aberco there?
Yep.
Any difficulty understanding the process?
No.
Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, no witnesses, simply a sentencing, which could be up to the maximum, regardless of what's recommended. You realize that? You have to say yes or no.
Actually speak up, Travis.
Yep, I was just getting ready. I'm ready. How are you?
With that in mind, as to one count of malicious mischief third degree alleged to have occurred within the city of Yelm on January 8th, 2022, how do you plead guilty or not guilty?
Yeah.
Say the word guilty.
Yes, Travis.
You need to say the word guilty.
Yes, Travis. Yeah.
And Mr. Keena, with regard to the amended charge of criminal trespass, second degree ownership occurred within the city of Yelm on March 2nd, 2022. How do you plead guilty or not guilty?
Yeah.
You make those pleas of your own free will.
Say yes, speak.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
I will find the pleas to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offenses. Now, the recommendation as to sentences, all jail time suspended on the condition you have law-abiding behavior, stay out of trouble.
Okay,
Is there
thank
anything
you.
you'd like to tell me or think I should know?
Well, thank you.
You don't have to say anything, but if you want to tell me anything, now's the time.
Okay, thank you.
Mr. Billy, anything further?
Nothing further, Your Honor. It's agreed recommendation.
Mr. Abaco, anything?
Nothing to add, Your Honor.
Mr. Keenan, sentence is 364 suspended, and 90, with 90 suspended on the criminal trespass second degree. Malicious mischief, that all jail time is suspended on that as well. Any question at all? Mr. Keenan, I'm going to wish you the best of luck. Unless you have some other hold on you, you're going to be released on this charge. And whether you go back to jail or not is kind of up to you. You stay out of trouble. Don't go where you're not supposed to go. Don't bother anybody.
Okay,
You won't have to listen to me again.
okay, thank you.
I'll take that as a no questions. You take care of yourself, and again, you'll be released unless you have some other hold on you. You take care of yourself.
Thank you. Have a good day.
Thank you, Your Honor.
Bye-bye. Good seeing you guys. Good to go?
Yeah.
Signature with the
And Judge, I thought I would just mention to you, I did speak with Nina Sanchez yesterday and actually reviewed the police reports, but I don't represent her. I haven't been appointed, but it was sort of perspective in that I was trying to figure out maybe if I could be of some help in resolving these matters. We did speak for a while. It's unclear to me what she wants to do, whether she wants to hire counsel or wants a court-appointed lawyer or, wants to set the matter for trial. So I'm not clear. So my intention was I can remain if Your Honor would like me to, but on the other hand, I'm thinking about I could just go back to the courthouse and Your Honor could just have a colloquy with her to figure out, what she is wanting to do.
I think probably the best thing to do would be to arraign her at this point. I'll appoint you to represent her. And then
Okay.
let's enter a plea of not guilty on her behalf.
And I guess then the question is, should I be appointed, because she has two cases on today, one's on for arraignment, one's a pretrial. So, I mean, I guess if she's indigent and I'm appointed to the arraignment case, I probably should be appointed to the pretrial case as well.
Yes, likewise. I'm going to.
Oh, okay.
Both matters.
Okay. But of course, we'll just wait to hear from her and see, who knows, maybe she's has intentions to hire somebody. I mean, I have no idea. Hey there, Nina. Why don't you come on in and have a seat? So Ms. Sanchez, I was just telling Judge Meyer here that, I gave you a call yesterday and we had a chance to kind of chat about your cases, and my impression was you weren't sure what you wanted. You weren't quite sure what you wanted to do. You were kind of weighing different, options.
Yes, sir.
So anyway, I guess I would just ask Judge Meyer, Your Honor, to inquire.
Ms. Sanchez, you're here for arraignment. You do have a pretrial set in an earlier case, but you're here for arraignment on a new charge of assault in the 4th degree, domestic violence. I'm going to appoint Mr. Haverko to represent you on both the new charge and the old one for at least purposes of this hearing we're having now. Now, it's your choice to accept him and keep him as your attorney. You can hire a lawyer if you wish to do that. You also have a right to represent yourself, but you do that at your own risk. Is your full name Nina Grace Sanchez?
Yes, sir.
I see the nod, but you need to say yes.
Oh, yes.
Citation I have alleges that on or about April 17, 2022, you committed the offense of assault in the 4th degree domestic violence. Charges a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverko to represent you, and he's going to enter a plea on your behalf at this time. Mr. Haverko?
Thank you, Your Honor. As to the arraignment matter, would stipulate to probable cause and then ask the court to enter a not guilty plea on that matter. Obviously, the arraignment's already occurred on the other matter. And we'd probably like, if you would just give me a minute, Judge, I'm assuming Ms. Sanchez is going to want to address conditions of release.
That's what we'll.
So I'm just going to mute here myself just for just a moment and chat with her for a bit, and then I'll thank you, Your Honor. Okay, Judge, back on the record here with Ms. Sanchez. She does have, she does have family in the area. She is employed in the medical field, so she has ties here, but she really doesn't, where she lives with her husband really is her primary residence. So she doesn't feel like she really has an alternative. I was asking her some questions about if there was perhaps, in case Your Honor inquired, whether or not there was an alternative optional place to live temporarily, but it sounds like there really isn't. She believes that she can come to some kind of agreement or understanding with her husband, the alleged, victim in the case, where somehow they can maintain an environment where they sort of stay. I think what she was trying to tell me was so they can somehow stay clear of each other, or somehow not run into this problem again. So she would like to be released. She did indicate that I believe she has to report for work tomorrow. So she does have some, like a lot of folks with employment, she does have some outside obligations. So she is concerned about that, doesn't want to lose potentially, that employment. So she would like to be released. So, and I guess in a sense, be given another opportunity to show that she can abide by the court's conditions.
I'll hear from the city.
Yeah, I've heard from the victim in this matter. He does not want any contact with her. There's actually a civil no contact order in place. So I think by allowing her in the house, she'd be violating that civil no contact order.
Travico, anything further?
No, I don't have any additional information to add really at this point.
Ms. Sanchez, community safety is probably the most significant concern I have with this case, but a fairly serious domestic violence charge in February, followed up by a more serious one in April, gives me a lot of concern for you. I have entered a formal no contact order. I want you to discuss the meaning of that with Mr. Haverco. Violation of that is a very serious matter. I'm going to leave bail the way it is, the way I said it when you were arrested on the most recent charge. We'll reset the matter for a.
It needs to be. I'm out the next court date, Judge, so it needs to be reset to May 26th.
That's what we're doing. That's what we're doing.
Okay. Thank you, Judge.
Ms. Sanchez, I'm hopeful that the situation will clarify itself a little bit. Right now, the order continues to be no contact at all with Mr. Sanchez, and that means in any way, shape, or form, telephone, email, in person, it doesn't matter. No contact means no contact. That concludes today's hearing. Take care.
Thank you, Your Honor.
Good morning. Call the matter of Yelm versus Kurt Borden. Matter set for a pre-trial. I guess I'm muted.
Yes, we're good. You are, but the court is not. We're just waiting for them to
We're waiting for
respond.
them to.
Yeah.
Good morning, Mr. Gurl. Good morning, Mr. Borden. I see you're both present.
Good morning, Your Honor.
Good morning. I see the matter is set for a pretrial this time. I'm going to turn to the parties for a statement as to the status of the matter. I'm looking at on Old Courts, an SOC. I'll turn first to Mr. Dilly on behalf of the city.
Yeah, there's an agreed order of stipulation continuance. I'll let council go through our agreement.
Your Honor, that is correct. And good morning. For the record, Dan Garrell appearing on behalf of Kurt Borden, who is also present here. Your Honor, this is we do intend to resolve this matter this morning in the form of a 24-month stipulated order of continuance. I have been in the process of going over that with Mr. Borden by phone. We're probably just a couple of minutes away from being ready to go on the record with that. And we've been doing this by phone. I'm actually on the phone with him as well. I would appreciate if we could maybe pass on this for maybe a court matter so that we can complete that. Either I don't know if we have the ability to go into a breakout room or we could just go back off of this and I could continue it on the phone with him. But again, we're very close and should be able to go on the record here shortly.
We don't have the breakout capability here for one reason or another. So what we'll have to do is we'll let us know when you're ready to go on record, and we'll immediately call call your case.
Yeah, we'll just go back to how we were 5 minutes ago, and I guess when I come back, should I do the hand raising or and that'll get court's attention perhaps to let them know that we're ready to go?
Absolutely. Let us know you're ready to go, and we'll immediately deal with your case.
All right, sounds good. Thank you, Your Honor.
He just
Right.
appeared.
I will go back on record.
Good morning again, Mr. Gerl. We're back on record. I'm looking at and I have reviewed the SOC that's on Oak Courts. I'll defer to you for presentation.
Thank you, Your Honor. Good morning again, Your Honor. I have had an opportunity to review the stipulated order of continuance with Mr. Borden in its entirety. We went over what this is. It's a contract between Mr. Borden and the city whereby both parties are agreeing to certain things based dependent on conditions being met. Mr. Borden understands he's given up the right not only to a speedy trial, but the right to a trial. He understands that what's going to happen here is this matter will essentially be continued for 2 years. During that time, again, the conditions are laid out here. He's agreed to comply with certain affirmative conditions as well as what I'll refer to as some passive conditions, things not to do. And he understands that the prosecutor will be bound, so long as he complies, will be bound to reduce this matter to a negligent driving after 2 years. And with a $750 fine, that's one of the conditions that he has to meet in advance. He understands that he has given up the right to a trial in this case, that in the event of a violation that was proved and a successful motion by the prosecutor for the court to revoke this agreement, the only trial that would happen would be Your Honor reading the police report that I expect will be offered as an exhibit, and Your Honor making a decision as to guilt that I would not have an opportunity to argue insufficiency of evidence or anything like that. He understands the maximum penalty that could be imposed on a conviction for DUI. He also understands the mandatory minimums that would have to be imposed. We've gone over any potential immigration consequences for either DUI or negligent driving conviction. And he does understand, although we do have an agreement in this contract that upon compliance, it would be reduced to negligent driving in the first degree and the matter closed, that technically negligent driving is a simple misdemeanor punishable up to 90 days in jail with a $1,000 fine. He understands that the terms that he is agreeing to, although I don't think that at this point there would be any scheduled court hearings, because according to Mr. Prosecutor, the final matter could be taken care of administratively without the parties needing to appear. I'm letting the court know that's what we're of the understanding of. I don't know if Your Honor has a different take, but our understanding is if he's in full compliance after 2 years, this matter will automatically be reduced to negligent driving and closed upon entry of the conviction. But if the court were to schedule any sort of court hearing, he understands he needs to appear for that.
I have the same take as you do. If there's full compliance, both parties are satisfied, doesn't need to be any need for reappearance. Mr. Borden, it'll be an automatic reduction and it'll go on your record as a negligent driving first degree conviction and not a DUI. With that in mind, yes, Mr. Borden, have you gone over the agreement with your attorney?
Yes, I have.
If you had any question at all, was your question answered?
No, sir, everything was answered.
There's a number of conditions there. The most important one to me is no criminal law violations, especially when it comes to consumption of alcohol and then driving. You're to get a drug and alcohol evaluation within the next 2 months and begin any recommended treatment within 90 days. Do a victim impact panel. There could be an issue of restitution that is reserved. If that becomes an issue and the parties cannot agree, your attorney and Mr. Dilly can't agree as to what that should be, you're entitled to have a hearing on that. You will. Now, you're to contact our probation compliance manager within the next week, I'm going to say, and her contact information is on the form that you're going to get a copy of. She's not a probation officer. She's there simply to monitor compliance with the terms of the agreement. Now, the monetary aspect of it is $750, which you can pay at $35 a month. And what your attorney indicated is absolutely correct. This is a contract your lawyers negotiated on your behalf for the city. You're going to get the benefit of that 2 years down the road from now if you're in full compliance and haven't violated the conditions at all. If you have violated the condition and the city proves that, as your attorney indicated, there's no trial, no appeal. There'll simply be a sentencing after I read the police reports and find, if I do find that there's a factual basis for a DUI conviction, that's what'll happen. I want you to keep in mind that driving a car is probably the most dangerous thing you're ever going to do in your life. And when you combine that with the consumption of alcohol, it becomes a potential for absolute disaster. All you have to do is turn on any news cast, and you'll get the latest information on the latest tragedy. A recent one involved an Auburn police officer. I'm sure your attorney's probably familiar with that. And there's nothing more tragic than the loss of a life when nobody had any intention of that happening. Mr. Morton, I'm going to wish you the best of luck. You owe your attorney a debt of thanks for negotiating this resolution. And whether or not you get the advantage of the agreement is up to one person, and that, of course, is you. So all I can do is wish you the best of luck, and you take care of yourself. Do you have any questions?
No, Your Honor. Thank you.
The girl, any questions at all?
The only thing, and I'll just do this on Mr. Bourne's behalf, when you indicated the need for him to contact probation, I had let him know because I was looking at the agreement that because there was nothing filled in there, I told him, I don't know whether or not that's something you'll need to do. It does sound as though that is part of what he needs to do. And I guess he would just call that number and then just make a contact with Cassandra. I don't know the last name there because it just says
There's a phone number and a email address there. And yeah, and again, her purpose isn't to have meetings with anybody or do anything. It's just to kind of keep track of this. And so our administrators here don't have to. It's a burden off their shoulders is all it is.
And Mr. Board, if you have any questions about that, let's talk offline on that.
Mr. Moore, once you've reviewed the document in its final form, give your attorney a call if you have questions, okay?
Okay, I will.
Best of luck. That concludes today's hearing. Take care.
Thank you, sir.
Take care.
Good morning. Both the public defenders are here, but they're talking to people as we speak, but I take it you're here for the 10 o'clock pre-trial time. On the record, I'll defer to Mr. Abaco for the order of the matters are called. Good morning. And this is Graf.
This is Buddy Graff. I just need to fill out need to log into Yelm Courts and we need to do a motion for continuance. Were you on the 10 o'clock or the 11 o'clock? 10.
Mr. Graff, good morning. Address your matter in a moment. Any conditions of release earlier said will remain in effect. It looks like we're going to be continuing your matter to another court date. Maintain contact with your attorney as well. Mr. Dilly, any objection to a release?
No objection, Your Honor.
Sign right there. Wait a second. Now do it. I prepared, Your Honor, a written motion order for continuance. I have discussed the speedy trial with the defendant. He understands what that is. So we are including in the motion a waiver of speedy trial. He needs to obtain a chemical dependency evaluation. And so I would ask to set it at least no less than 4 weeks, because he does have an appointment apparently today. And so
Set it out a month, 6 weeks.
yeah, 4 or 6.
Let's go 6. With coming out of COVID, things are a little backed up, right? From what I understand. So Graff, again, stay in touch with your attorney, and expect you back here on June 9th, 10 o'clock in the morning. So Graff, I'm signing electronically the reset order. You can get a copy of that by going to the window outside the courtroom and to your left. Any questions at all? No. Good luck to you. See you in June. Take care.
Take care. Ready.
Okay.
We can take it from there, Mr. Chicago.
Pleasure.
Thank you.
Mr. Shidako, good morning. We'll address your matter at this time. You appear to be muted. If you would unmute yourself, we'll address your matter. Your attorney's in the courtroom.
Good morning, Your Honor. How you doing today?
Good morning. We hear you fine. I'll defer to your attorney for the status of the matter.
Thank you, Your Honor. Good morning, Mr. Shintaku. This is Dan Haverko here. This matter comes before the court on a pretrial hearing, and the parties have reached an agreement, that being stipulated order of continuance. I've discussed with Mr. Shintaku what that is and what it involves. I've prepared one and asked the court to inquire.
Mr. Shidako, I'm looking at on the computer screen a stipulated order of continuance. Have you gone over that with your attorney?
Yes, we have, Your Honor.
And it's an agreement under the terms of which the matter will be continued for a period of 12 months on some conditions. The conditions are show up for court when scheduled and have no criminal law violations over the next year. You realize that?
Yes, Your Honor.
If you comply with the agreement, the charge will be dismissed. If you violate it and the city proves that, in return for the agreement, you give up your right to go to trial. We would simply have a hearing based on the police reports that would result almost certainly in a conviction, which would subject you to 1 day less than a year in jail and a pretty hefty fine. I'm going to wish you the best of luck with this. You take care of yourself. Do you have any questions?
I do have a question, Your Honor. The person that I tried to evict from my home is my daughter's boyfriend. If it is friendly contact, is that something that I can or cannot do?
I'm not sure I understand. The $250 is also involved at the rate of $25 a month. I don't see anything in the order by way of no contact. The just general law, principles of law would apply at this point. You can't assault him. I realize, especially right now, post-COVID, or getting on towards post-COVID, the landlord-tenant relationships are worse than usual. But anything that you're legally entitled to do, you're fully entitled to do just that.
Okay, yeah, they've already moved out, so that's not, my wife made them move out the day this happened, so that's not a problem anymore. So we should be okay.
You're lucky there.
Yes.
I'm going to wish you the best of luck. That concludes the matter. I'm electronically signing off on the agreement. You'll be sent a copy of that, as will Mr. Haverko.
Oh, one more question, Your Honor. Will I get a bill in the mail, or do I just need to come down once a month? How will that work?
The mail's fine.
Will that come to my home though, or how do I send that in? Will a bill come to my house and then I just return it, or how does that work?
Well, no, what you're gonna get an order, and typically the clerk will prepare, whether you pay it off at once or pay it over time, typically the clerk will draft up a time payment agreement. So it's going to be your responsibility to remember when and how much to pay. But the court's not going to send you a bill or any kind of invoice. You need to remember.
Okay.
If or as an option, you can just pay the entire amount in full, and then if you do that, you can just forget about it.
Okay, and but the initial agreement will be mailed, is what you said, Your Honor?
Going to be mailed to you, and the fine is $250.
Perfect.
Payments are set at $25 a month. First payment due May 28th.
Perfect. Thank you, Your Honor.
Mr. Shidako, good luck to you. You take care. Have a good day.
And thank you, Daniel.
Yeah, am I good? Yeah, okay.
Mr. Steven, good morning.
I have Dana Brown with me. Ms. Brown is numbers 2 and 3 on the 10 o'clock calendar. And I have a plea form that I've executed and gone over with her in Yelm Court, Your Honor, if the court would like to take a look at that. Upon successful entrance to that plea, the city is going to be moving to dismiss the tracking infractions.
That's correct.
Ms. Brown, good morning. Full name Dana D. Brown.
Correct.
I'm looking at a statement of defendant on plea of guilty to 1 count of operating a motor vehicle without ignition interlock when required. Plea form tells me you're 60 years of age. You've been through the 12th grade. Any issues at all reading, understanding the plea process with your attorney?
No.
You understand if I accept the plea, you're giving up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be up to the maximum, but that would be 364 days in jail and or a $5,000 fine, regardless of what's recommended. You understand that? With that in mind, as to one count of operating a motor vehicle without ignition interlock when required to have that by law, that should have occurred within the city of Yelm on March 5th, 2022. After that, how do you plead guilty or not guilty?
Yes.
The plea is guilty
Yes.
do
Guilty.
that
Oh,
if
do
you
I
don't
say
like- you're
guilty?
fine, yeah,
of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
We'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Accept the plea, and on the city's motion, ticket ending in 972 will be dismissed. The recommended sentence is 364 days in jail, but all suspended on the condition you have a law-abiding behavior and don't drive unless licensed and insured, and of course have ignition interlock if that's required, and pay a $250 probation fee. City, have anything to add?
Nothing to add, Your Honor.
Mr. Steve, anything to add?
Only, Your Honor, that she's trying to get this case resolved. It's the reason for this whole thing, and she's working diligently to do that. Has a new attorney on the matter over in Yakima. I don't anticipate us ever seeing her again. Thank you. We just asked for payment plans.
Well, we have these rough patches in life. We all do, but this one will get behind you, and you know, the Department of Licensing beats you over the head with more help and sanction than you possibly ever need, but that's just the way it goes. I'm going to follow the recommendation. All jail time suspended on the condition you pay a $250 probation fee and have law-abiding behavior. Now, the money is the last thing I want you to have to worry about. If there's a problem making the payments on that, let us know. Let us know. And that's something we can easily deal with. Any question at all?
Nope.
Sometimes I think it takes me longer to review and sign what's in the computer screen here than it would take me to simply review and sign. You know what they say about old dogs that do tricks.
Come on, Dan.
There's on the
Oh.
JNS.
They're more working on it. So
I'll need a signature.
As long as you let me know, so I know.
Need a signature from all parties on the JNS. Throughout eventually all these requirements, they drop off and you can go on with life a little smoother. Don't know what's going on over on the other side of the hill, but I'm gonna wish you the best of luck with it.
Thank you, Your Honor. Southeast, Jason.
And do we need, I'm gonna click that, close that right now. Anything else? Are we good?
I think that's it. Ms. Brown, you can get a copy of today's ordinance. I'm gotta sign this. Mr. Dilly has to sign it as well. But you can get a copy of today's paper by going to the window outside the courtroom and to your left.
Okay,
And review it carefully. And if you have any questions at all, give Mr. Steve a call.
thank you. Do I pay here too in this building? Do I
Pardon?
pay my
When you
fine
pay,
in this
yes, you
building?
can pay it here.
Okay,
Fines are, probation is set. Let me go back up. These forms are a lot longer than they need to be. $25 a month, first payment due May 28th.
thank you.
Yes, you can.
Okay, I can
go.
go. Okay, thank
Yes,
you.
thank you. Good luck. Next matter, Your Honor, is Danielle Tyndall.
Morning, Beth.
Morning.
Ms. Tyndall also comes on for a pretrial, Your Honor. She's number 9 on my 10 o'clock calendar. There are 2 matters here. We have a plea form in Oak Courts. Ms. Tyndall's going to be pleading to 1 count of theft in the 3rd degree. Upon successful entrance of that plea, count 2, criminal trespass 1st degree, will be dismissed. $150 probation fee, stay out of Walmart, no law violations for the next year is the agreed recommendation. Thank you.
Do you disagree with anything your attorney just said?
Do I disagree? No, Your Honor.
For the record, your name is Danielle Julian Tyndall.
Yes.
Plea form I'm looking at tells me you're 35 years of age. You've been through the 12th grade. Any problem at all following the conversation with your attorney about the process?
No.
You've gone over the plea form with Mr. Steven?
Yes.
The plea of guilty that I'm looking at would be to 1 count of theft in the 3rd degree. Maximum penalty for that on conviction would be 364 days in jail and or a $5,000 fine, which I'd be free to impose regardless of what's recommended. Accept the plea, give up the right to contain in paragraph 5, no trial, no appeal, simply a sentencing. Now, with that in mind, as to 1 count of theft in the 3rd degree alleged to have occurred within the city of Yelm on October 2nd, 2021, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
Find your plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. The recommended sentence is all jail time, 364 days suspended, on the condition of a $250 probation fee, and more importantly, law-abiding behavior. And of course, if you're trespassed from someplace, that means stay out of there as well. Mr. Steve, anything further?
Nothing further, Your Honor.
Mr. Dilly, anything to add by way of?
No, Your Honor.
Ms. Tyndall, you have a right to tell me anything you want. You don't have to say anything, but if you have anything you think I should know, now's the time.
No.
Right. I'm going to follow the recommendation. All jail time suspended for a year on the condition you have law-abiding behavior and pay a $250 fine. We don't learn from our mistakes. We're condemned to repeat them, and we always do. So hopefully this has been a learning experience and one not to be repeated. Okay.
Thank you, Your Honor.
I'm reviewing and editing the form. And I've now affixed an electronic signature to the judgment and sentence, and you're going to get a copy of that if you go to the window outside the courtroom to your left. And once again, review it carefully, and if you have any questions about anything that's contained in it, let Mr. Steven know. And if you have any problem or any issues with making the fine payments or the probation payments, again, let us know. That's very easily dealt with. Any questions?
No.
Good luck to you.
Thank you.
Take care.
You're welcome. Next matter I have, oh, sorry, are we ready?
Back, you bet.
Always got to check. Again, I'm still waiting for, of course, to put that stoplight feature on there, so I know if we're actually ready to go.
I'll hold up my hand.
Okay. Wouldn't that be helpful, like a red light, green light, to know if
Red light, green light.
if you're done? Yeah.
Or Denny shot.
Yeah. Okay. Gotta find it on the computer, sorry.
Good morning, Mayor.
Good
Thank you,
morning.
Your Honor, and this is Ms. Perez Murray, number 8 on the 10 o'clock calendar. And the city has a motion in this matter, and I'm going to briefly preface it with Ms. Murray, only by a few days when this took place, I believe, or a very short period of time, became an adult. So this was handled essentially as it might through a juvenile diversion process, and she completed some necessary coursework. And so the city's going to have a motion in this matter. Thank you.
That's correct, Your Honor. City's going to dismiss without prejudice.
I'm looking at the order. I'm gonna, sure you have no objection to me simply dismissing the charge.
No.
Now, I'm just gonna ask you to keep in mind that driving a car is probably the most dangerous thing you're ever gonna do in your life. And you're taking your own life and the life of everybody else on the road in your hands. So when you get out there on the road, so please, drive carefully, drive safely, get to where you're going safely and without incident. Good luck to you.
Thank you, sir.
If you need a copy of the order of dismissal, you can get that at the window.
Thank
Take care
you.
of yourself.
Thank you. Good luck.
Yeah, thank you.
Okay, Your Honor, I can move through. It's like I move through the entirety of my calendar now that we're after 6, or excuse me, after 6 after 11. But if the court's ready, I have number 4, Sarah George. I've executed a motion to continue. I'm going to ask for a date in late August. Need to check and see which date are our court dates in late August.
We're going to look at that first court date in September.
Or the first court, that's fine. Yeah, sorry. That'd be September 1st. So yes.
Number 1. And you're in contact with Ms. George.
Yes, in fact, we've been emailing all morning. So yes, sorry. Yeah, I've been in contact with her.
We set to September 1. And we'll send her and herself a copy of the reset.
I appreciate that. I'm gonna put that down here as well. Next is.
Any shot?
Oh,
Still.
sorry.
Sorry, of course, it's
Red light.
slow.
The red lights. Yes.
Red light, red
I'm
light.
telling you, that would be helpful.
He just needs a flag.
I have through
If
two different,
Should be ready.
in 2 different courts now, I've requested that they add a signature block for defendants so that we can type in the electronic signature notation, so I don't have to do initials with, and they just like don't respond to it. I would think that would take those guys that like 2 minutes. 'cause
an instant.
we already have that code. It's on other lines. So anyway, whatever.
One would think.
One would think.
One would think. Green light.
All right. The next matter I have ready is Miss, I already did George, didn't I? I'm sorry. No, I don't have this ready, but I think we can address it. Sean Gilbert. Can't remember if Mr. Gilbert appeared at the last hearing or not, or if he appeared late, but I don't have any updated information to provide the court. I looked at this earlier. Hang on a second, and I can.
They didn't catch who that was.
Sean Gilbert. It's like there's failure to appear.
Docket, says box checked.
Yes. I don't have any information to provide the court about his whereabouts today.
$2,500 cash or bond?
So ordered.
Next matter is Ashley Harper. This has been reset a number of times. We're waiting for some things to happen or to not happen, I should say. And I believe the city has a motion in this matter as well.
Yeah, city's going to move to dismiss without prejudice.
No. Objection.
I am now signing electronically. Green light.
All right. So other two were handled. Miss Bodenmiller. Number one, off the. Can't remember if, how did I say her name? I hope I got.
Christina Bodenmiller, I'm gonna guess.
Let me see. And I apologize, Your Honor. I thought I did a motion to continue in this. Ms. Bodenmiller and I have spoken a number of times. We're working on a resolution of this. It's going to require that she save up a little money. And she's currently in Eastern Washington and without a phone. And so
How far out would you like to?
I would like to go to the first court date in, actually, I should put this on the record. I'm going to be unavailable June 23rd. I'll explain more maybe off the record, but I have a trial that date. It's looking like, so I would like to go to July 7th if possible.
No objection. We'll reset Ms. Bodenmiller to July. So
we are not objecting to noting this also for the purposes of speedy trial noting the FTA, so we have time to resolve this how we'd like to.
nothing on appearance for speedy trial purposes.
Okay. Similarly, Your Honor. Dolores Burns.
I'm still signing off on.
Oh, sorry, I forgot to.
I had to punch the refresh button to bring it up. Really?
All right, I'll need to, Ms. Burns, I'll also need to go out to July 7th. This is a very similar situation. We're trying to get some money together to resolve this case, potentially with a compromise of misdemeanor. Unfortunately, Ms. Burns has lost some family members and is dealing with probate issues, which are eating up resources. So we need a little bit more time. Yeah, it doesn't sound very fun. So.
That doesn't sound very. Signing the order reset. Okay.
Next is Mark Cunningham. And I don't have any information to provide the court in that matter.
Assault fourth degree, $5,000 cash or bond.
I read the note on the docket. So ordered, 5,000 cash or bond.
Okay, next matter is Logan Elliott. There's a reset form in the courts for Mr. Elliott. He's currently, and I've had some discussions with him, and he's currently in treatment, and he's gonna be in there for a little while longer. So I am gonna, but not, like, I don't think, way longer, so I'm gonna ask for the, let's just try a month. If he's still in, but I think he'll be out by then. Let's move this to May 26th, if that works.
We can, if he's still in treatment, we can reset it again.
And I've talked to him and his counselor, so.
What about he has an active warrant with us right now.
It does look good. Active warrant out of Olympia, Muni.
Good with us.
Yeah, this is one where he set it on and I think was supposed to appear.
Are we gonna leave our warrant in place?
If the court's willing I noted the FDA for the purposes of speedy trial. So if the court's willing to quash the warrant, we won't restart I stipulated to not restarting any speedy till he gets back here. If that's okay.
City, have any objection to quashing the warrant?
No objection.
Yeah, let's quash the warrant, just note the non-appearance.
Okay. And just for the record, we've probably talked 3 times, and I've talked to his counselor at least twice, so he's been making a lot of efforts to reach out to me.
He's in contact.
He's in contact.
That is the important.
Yep.
Good.
Are we ready for the next one?
Ready.
Okay. Mr. Sean Ray Bauman. It's like a new case. I have no information to provide the court on that.
Box is checked. Sean Charles Ray Bowman. Criminal trespass, first degree.
$2,500 cash or bond.
So ordered. And that brings us to
Mr. Williams.
Hi,
So I
Mr. Williams.
spoke with him a couple weeks ago. I spoke with him again this morning. We've executed a form to reset this. I'm going to ask him and I need to get together. There's a fair amount we'll need to discuss. So I'm going to ask for the 7th of July on this as well.
July 7th it is. It'll take a minute. Got it.
That's it.
That is all she wrote.
I think we should have,
Mr. Mucklestone.
Yes, we do.
Is he?
for,
Me?
no.
No, that's a private
Private
counsel.
counsel.
For some reason we have.
And I
Good
think.
morning, Your Honor.
So we're going to say good afternoon, or hey, still good morning.
Yes, how are you?
So far, so good. How about yourself?
Doing good, Your Honor. I did have a chance to go over the proposed resolution in this matter.
which is a stipulated order of continuance. I went over that with Ms. Buckingham, and we do have it in O Court at this time.
Hey, Ms. Buckingham, I can see that you're present, but you're muted. If you'd unmute yourself, your attorney will address your matter at this time.
Looks like she's unmuted, Your Honor. Katie, you there?
Yes,
Thank you. We can hear you.
sorry.
Hey, no problem, no problem. I'll turn to your attorney for the status of the matter. I'm looking at on the computer screen an SOC. Mr. Mucklestone, I'll turn to you for presentation.
Thank you, Your Honor. I did have a chance to go over the stipulated order of continuance in this case. 1A0713-068, City of Yelm versus Katie Buckingham. And it looks like in this case, we have a speedy trial waiver through August 29th, 2023, a 12-month SOC, which will amend the DUI to reckless endangerment, and a probation fee of $500, beginning at $50 per month, beginning May 28th, 2022. And we have conditions of 1, appear timely at all scheduled court hearings; 2, no criminal law violations; 3, don't drive without valid license and proof of liability insurance; 4, don't be in physical control of a motor vehicle while driving with an alcohol concentration of 0.08 or more, or THC concentration of 5 nanograms per milliliter of whole blood or higher within 2 hours of driving; no alcohol-related infractions; don't refuse a blood or breath test; don't refuse a breath test or urinalysis upon request of the court or probation. And in this case, we've done the alcohol drug evaluation as well as the ADIS and victims panel. I need to file those with the court, which I will do following the hearing. And I've gone over all of this with Ms. Buckingham, who understands it. And I did fill in her address and email and cell phone down at the bottom there. And I believe that this particular resolution is done knowingly, intelligently, and voluntarily. And Ms. Buckingham does understand that she's giving up the important constitutional rights of, or at least in speedy trial, constitutional right to a jury trial, see, hear, and question witnesses who testify against her, the right to call witnesses who would testify on her behalf, and the right to testify on her own behalf. She understands that in order to be afforded this resolution, she's going to have to waive those rights, which she does knowingly and freely.
Ms. Buckingham, we've heard from your attorney. Do you disagree with anything Mr. Mucklestone just said?
No, sir.
The conditions, but I'd like to reiterate with regard to a couple of them. The most important thing is during the period of the agreement, this is for 1 year, that you have no law violations relating to especially alcohol consumption. And that you do the drug and alcohol evaluation within the next 90 days and comply with any recommended treatment. Sounds like you're well on the way there. And the purpose of that is, hey, if there's an issue, let's deal with the issue so it doesn't come back again. $500, but you can pay that over time. Now, at the end of the 1 year, the charge will be, if you're in full compliance, amended to the lesser offense of a reckless endangerment. That's sort of an unusual resolution in an SOC, but just an excellent one in your case. Now, in return for the agreement that your attorney has negotiated on your behalf, you've given up your rights to go to trial, have witnesses, appeal if you lose. If there's a violation and the city proves that, we'll have a hearing that'll be based on the police reports, and you know where that will take us, and we don't want to go there. Mr. Mucklestone has put you in a position to have this behind you with minimal damage, but now it's up to one person to comply with the agreement that's been entered into, and that person, of course, is you. I'm just going to ask you to remember that you get behind the wheel of a car, that's just driving is probably the most dangerous thing you're ever going to do in your life. And you add alcohol to that, boy, that's potentially a disaster. You may be familiar with a case that happened with regard to an Auburn police officer not too long ago. Such incidents are absolutely tragic, and I wouldn't want you to be involved in any such thing at all. I'm going to wish you the best of luck, and Hey, we have to learn from our mistakes. We all make them and go on to make new ones. But you got to learn from the ones we've made. Any questions at all, Ms. Buckingham?
No, sir.
I'm going to wish you the best of luck. We will be sending you a copy of the agreement. I want you to go over that, and if you have any questions at all, give your lawyer a call, okay?
Yes, sir.
Mr. Mucklestone, anything further? Any questions?
Your Honor, no, there will be no questions here. And my understanding was after the year, it's amended to reckless endangerment and then case closed, correct?
That's absolutely correct. No need to reappear. The only need for reappearance will be if there's a problem with the compliance.
Okay,
It'll be automatic without need for reappearance.
okay. Thank you very much, Your Honor. I have nothing further.
Hey, thank you. That concludes the hearing. Ms. Buckingham, again, you'll get a copy of today's agreement, review it, consult with your attorney if you need to. Good luck to you again.
Thank you.
Have a good day, Your Honor.
Hey,
You
thank
too,
you.
Emily.
Take care.
Bye.
Fixing signature. Oh, well. Well, I was just handed just got a phone call from Ms. Aronson. She's Mr. Haverco's client, if I recall correctly.
Yes, number one.
Car problems on highway, cannot make it.
All right, we'll go ahead and kind of reset that.
That will note on appearance for speedy trial purposes and reset with notice to both Mr. Haverco and Ms. Aronson. And that
So I guess that leaves the 8:15.
That does. I just plowed my way through the. That brings us back to the 8:15 docket. It was unanimous in the fact that nobody showed at all. First one is Jason Bishop. That's an SOC.
$5,000 cash or bond.
So ordered. It looks like Alan Brown. That's that no contact order, et cetera, with Don Bateman. It looks like that's already in warrant status. Order remain in effect. Then Frederick Douglas. No, Douglas Frederick.
$5,000 cash or bond. Hello.
Hi. This is Peter, and I called some of the students not.
And you're.
Tasha.
Oh, you had car problems on the freeway.
Yes.
Perfect. I'll let Mr. Haverco know you're here.
Mr. Haverco is around here someplace. We'll go ahead and have a seat. We'll find him. We were going to reset your matter because of your phone call, but it looks like since you're here, we may as well do something.
Okay.
But car okay?
Yeah, it's having trouble starting and it's.
That's, if it's automotive, you're going to have troubles with it.
Yeah. Yeah, we just switched the alternator and still having problems, so I don't know.
Oh, boy. That's nothing worse than having to be someplace and flat tire, car won't start, car breaks down.
Was I the only one scheduled for today?
Pardon?
Was I the only one scheduled for today?
Oh, no, it's just that we've just gone through everybody. That's
Oh.
just went through the non-appearances and,
Thank you.
Ms. Aronson?
Yes.
How are you?
Hi.
So last we left,
we had one left, and that would be Michael James Pendley.
5,000 cash or bond.
So ordered. Back on record, Mr. Arnson's case,
Yeah.
introduce you here for a pretrial.
Yes, Your Honor, yeah, this is Tasha Aronson, comes on today for a pretrial hearing on the theft third degree charge. Had an opportunity to meet with her. We'd like to conduct some additional discussions on the case, so I've prepared a motion for a continuance. We'd like to continue it maybe 4 or maybe more likely 6 weeks. She signed the form and it includes a speedy trial waiver.
6 weeks. Ms. Aronson, thanks for appearing. We're going to reset your matter out to about 6 weeks. That'll be to June 9th at 11 o'clock in the morning. Stay in touch with Mr. Haverco and we'll see you back here in June.
Okay, all right, thank you very much.
Take care.
Hold on, that so you can get a copy of today's order with a time and date on it out the window. Get that before you leave.
Okay, all right, thank you.
Hey, thank you. Mr. Sanders is on. Mr. Dilly, good afternoon. Apparently, Mr. Rikers is in the courtroom, and I think Mr. Sanders is on Zoom. We're going to take that matter now, if Mr. Sanders is available.
That sounds great.
Mr. Rikers, come on up and have a seat at the council table.
He is there, I think he's.
Mr. Sanders, good afternoon. It looks like you're muted. If you unmute yourself, we're going to call your matter now.
Yes, sir. Thank you.
Good afternoon. Before the court is your full name Nicholas Aaron Rikers?
Yes, Your Honor.
Mr. Rikers, the citation I have alleges that on or about April 17th, 2022, you committed the offense of driving under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty of conviction would be 364 days incarceration and or a $5,000 fine. I'll turn to your attorney for the entry of a plea in the matter. Mr. Sanders, if you wish formal advisement of rights or probable cause, we can proceed to that way. I'll defer to you.
And thank you, Your Honor. We'll stipulate probable cause for purposes of this hearing. We will acknowledge receipt of the alleged complaint. Way further formal reading and respectfully enter a plea not guilty at this time.
We will set the matter for a pretrial. How far out would you like to go with it?
Well, June 9th would be great, but I could do May 26th if we had to do May 26th. But the Thursday, the 9th of June would be really nice, I think.
Really, any objection to doing it on the 9th of June?
Nope, no objections, Your Honor.
June 9th it is. That'll be at 9 o'clock with a private attorney matter. Mr. Rikers, conditions of release would be don't drive unless you're licensed and insured. Don't drink and drive at all. If anybody asks you to take any officer asks you to take a breathalyzer, you're to do so. Mr. Sanders, I see a prior, but that's back in 04, well beyond the 10 years. Mr. Dilly, any additional conditions of release?
No, Your Honor.
Mr. Sanders, any questions at all?
No, sir. I believe we'll be good June 9th at 9 a.m. For a pretrial.
Mr. Rikers, I will sign an order setting the time and date for the pretrial. You can get a copy of that at the window outside the courtroom to the left, and we'll also be mailing your attorney a copy of today's order. Any questions at all?
No, Your Honor.
Good luck to you. We'll see you back here on June 9th. Take care.
Thank you.
Mr. Sanders, that concludes the hearing. You take care. See you in June.
Yes, sir. Thank you very much. Thank you, counsel.
Thank you.
Signature, save signature.
We do have Miss Bowden.
We do have Ms. Bowden?
Yes, but
Mr. Koch? Yes. Okay.
not that I see.
Next call the matter of Yelm versus Mr. Gotch. Ms. Bowden apparently is on.
Yes,
Ms. Bowden, good afternoon. You appear to be muted. If you'd unmute yourself, we'll take your matters at this time.
Okay, is that better?
Certainly is. Now I can hear you.
All right.
Good afternoon.
Good afternoon, Your Honor. I have Mr. Gotch here with me. This is going to be a defense motion to continue. I know you have an interpreter scheduled, but I'm okay if we just pick a new date. I'll give it to him.
The interpreter is available and online if you'd like her, but if you don't, we can simply reset the matter. Mr. Dilly, if you have no objection, we can simply do that.
No objection, Your Honor.
Ms. Bowden, how far out would you like to go?
I'm probably gonna need 60 days. You're not going anywhere? No, 60 days?
Hearing no objection from the city, we could certainly do that. That would take us to everything is bound around O courts, which means got to fire up the right paperwork here.
Are you doing that or you want me to?
That's what we're doing right now.
Okay, I can do O courts for my next one, which is a plea, right?
Absolutely.
Okay.
End of June, second week of June. June 23rd. That would work out to June 23rd. And of course, at 9 o'clock as usual.
It's actually gonna be at 1 because the interpreter's only.
And that would be, again, wait a minute, not 9. That would be at 1 o'clock because that's the only availability that the interpreter has.
Okay, and what is the day again? June 29th?
June
23rd.
June 23rd.
June 23rd at 1 o'clock.
1 o'clock.
Okay, we'll get that in the book and I'll send him on his way. New date.
Now opening today's order. Editing the same.
I'm gonna work on my plea form, okay?
Pardon?
I'm gonna work on my plea form.
We have a resolution in that matter, Your Honor. So why don't we go ahead and we can continue on the calendar and just give us the high sign when you're ready.
This is in connection with your other case.
Yeah, that's Miss Lagonzo.
And go ahead and message the interpreter that no longer needed.
I can't message. We don't have that ability anymore to message.
You'll bring her up.
Yes, he's there.
Ms. Colson, good afternoon. How are you? The computer screen tells me that Ms. Colson is present and appears to be unmuted. Ms. Colson, if you can hear me, please sing out. Is Maria Colson able to hear me? Mr. Dilly, for some reason, we do have the interpreter present, but inaudible or mute. That's with that in mind, we'll go to go back to the head of the calendar. You're here for an arraignment, which is your first appearance after receiving a criminal citation. Before I call you up one at the time, I need to advise you that you do have a right to have a lawyer represent you at all stages of any criminal proceeding. If you're indigent, I'll appoint Mr. Haverco, our public defender, to represent you throughout the course of the matter, but he will at least represent you and enter a plea on your behalf today. Typically, a plea of not guilty is entered at this proceeding, and the matter is then set for a pretrial, which is a chance for you to go over your case with your attorney, decide whether or not the case is resolvable by agreement. Sometimes that can happen. If it can't, you do have a right to a public and speedy jury trial in the county where the offense allegedly was committed. If you have any question about your rights or what you're charged with, either ask Mr. Haverco or myself, and we'll do our best to answer your question. Is Jack Chenier here? Jack Chenier? How about Donnie Colvin? Donnie Colvin is not here. How about John Herzog? Does not answer. Anthony Navarro. James Seeley. Mr. Seeley, I haven't seen you in a while, but hey, come on up and have a seat if you would.
Your Honor, while Mr. Seeley is making his way to the dais, city has a motion, and that motion is to amend the charge from DDLS third to Noval second degree, recommend $150 fine.
You know what just happened? I do. The city amended it to a civil infraction instead of a criminal matter. I think we've been down that road before. If you admit the infraction of no valid operator's license, second degree, I'll impose a $150 fine. That will conclude the matter.
That will be fine by me.
That's a 150 it is. Now, do you know what you need to do to get relicensed?
I'm looking into that.
Good luck with that.
Yeah.
Good luck with that. Payments will be $25 a month. First payment, May 28th. I'm signing the today's order as we speak. Mr. Seeley, you can get a copy of it by going to the window outside. Any questions at all?
First payments today for 25?
May 28th, $25.
That's today, right?
Today is the April
Okay.
28th,
Okay.
a month from now.
Okay.
A month from now.
That's fine.
But I want to urge you to do what you need to do to reinstate your license.
I know. No.
Always a good idea. You
Okay.
take care of yourself and have a good day.
Thank you.
Thank you. And I think I finally learned how to pronounce your name correctly.
You always do.
Thank you.
Do I?
Yes, go ahead, go out to the window and you'll get a copy. Ayla Marie Scheidek. But Michael Shore. Mr. Shore, good afternoon. Go ahead and have a seat. For the record, your name is Michael Stephen Shore.
Yes, Your Honor.
Citation I have alleged that on or about April 16, 2022, committed the offense of assault in the fourth degree domestic violence. That again is a gross misdemeanor. The maximum penalty on conviction would be 364 days incarceration and or a $5,000 fine. I will at this point appoint Mr. Haverco to enter a plea on your behalf.
Thank you, Your Honor. Stipulate to probable cause as the court to enter not guilty plea.
We have not guilty submitted on your behalf. When we spoke on the telephone, I did, as a condition of release, have no contact with the Brittany Shore. That remains in effect until we change that. Any questions at all?
Many, but no.
Right. Mr. Shore, we're going to set a pre-trial. I'll have a date for you in a moment. Condition to release, in addition, is law-abiding behavior. May 26th at 10 o'clock will be your next court date.
8683.
Yes.
Sure.
Go ahead about getting the discovery to this case.
That will be sent to your attorney and he'll go over it with you once he gets it.
I don't know if this is the right grounds, but I want an attorney. I'll be presenting myself. So is that a conversation with him here on that?
You do have a right to represent yourself. You'll be held to the same standard as a lawyer is. I don't know how much experience you have with me, but that's kind of a dangerous course of action to go down. But you have a right to do that. You also have a right to hire your own attorney. That's your choice. I'll have Mr. Haverco enter a plea on your behalf at this time. And there's court rules about the dissemination of discovery. That is something you're going to have to take up with the city's prosecutor. That's Brett Dilley.
Right.
We're going to set a pretrial for May 26th at 9 o'clock a.m. And we'll have you representing yourself at this time. Any idea? Are you going to hire a lawyer? Have him or her appear if you do that?
No, Your Honor. I intend to represent myself in this matter. And that court date is set for at 9 a.m. on what day?
Yep, May 26th, 9 in the morning.
Go ahead and sign here. You're signing the order that requires you to appear?
Oh.
Now sign the order electronically. You get a copy of today's order by going to the window. You take care, and we'll see you back here in a month.
All right, yes, Your Honor, thank you.
Thank you. Terry Sortino. You have to come on up and have a seat. Is your full name Terry Austin Sortino?
Yes.
Mr. Sortino, the citation I have alleges that on or about April 14th, 2022, you committed the offense of violating the terms and conditions of a no contact order. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days incarceration and or a $5,000 fine. I'll have Mr. Haverco enter a plea on your behalf.
Thank you, Your Honor. I stipulate to probable cause, ask the court to enter a not guilty plea.
Plea of not guilty has been entered on your behalf. Mr. Sortino, I realize the contact was allegedly consensual, but however, no contact means no contact. And of course, that until a court that entered that order modifies that, that remains in effect. And abiding by that will be a condition of your release here. Any questions at all?
No, Your Honor.
Right here. Oh, do you need to check it? Do you know the number? Just check it. Or call me. They'll give you a piece of paper. Just make sure.
Sortino,
Don't sign, just, I needed a number, but if you don't know the number, then just call. And you need to sign here. Sign on this. Or sign order requiring you to reappear. State. Go, just check with the clerk before you go, and she'll give you a printed copy of all this stuff. You bet.
May 26th, 10 o'clock, that's the date of your pre-trial. I'm signing the today's order as we speak. Started to do that line. So here. Abigail Tate, that matters in warrant status, no appearance. Gary Woods, no appearance. Sortino, you can get a copy of today's order at the window outside the courtroom to your left. Thank you for appearing and thank you for your patience, and you take care.
Thank you, Your Honor.
And that, except for the attorneys.
Docket number 10, Ms. Shadek said that she would be a little bit late. Her bus was running late.
You didn't hear that, Miss Shadek is called and the bus is running late, and she'll be here when she gets here, but well, I guess right now we're waiting on Ms. Bowden.
Yeah, and I have just, there's a plea in Oak Courts of which I've just signed.
I was gonna say, I'm gonna go ahead and I guess take off, but if we could just on Ms. Scheidek, if she does show, just note her lateness as an FTA and we set it, or did the court want me to wait, or?
If you have to leave, that's what we'll do.
Well,
if it does,
I mean,
I'll leave it up to you.
She should be here, I think she said by 1:30.
Oh, wait till 1:30.
1:20.
Yeah.
Yeah, I mean, it's
Hard to
just,
tell with
you
the
know,
bus,
people
so.
say 1:30.
Finally, huh, Deborah? I'm so ready for this.
We'll call that one now. I'll defer to you for the status of the matter.
Thank you, Your Honor. Your Honor, it's my understanding that the city has amended the DUI charge to that of a reckless driving. I just went over the plea of guilty with her. She understands the maximum penalty is a year, and 364 days in jail and a $5,000 fine. She understands there is no minimum except a 30-day license suspension. She understands all the rights, and I believe it's paragraph 6. We went over there, those individually, and she does understand that she's giving up those rights by entering this plea of guilty. I wrote out a statement. She adopts it as her own. She's making the plea freely and voluntarily. She understands the prosecutor has made a recommendation, but the court's not bound by that. The court can sentence her up to the maximum.
Hey, thank you, Ms. Bowden. Ms. Longo.
Say yes.
Yes.
Good afternoon. Is your full name, and for the record, Deborah Sue Longozo?
Yes, sir.
I hope I pronounced that name correctly.
You did.
Thank you. But do you disagree with anything that all that Ms. Bowden just said?
Do you disagree with anything that she just said?
No, I don't disagree with anything.
What I'm looking at a statement of defendant on plea of guilty to 1 count of reckless driving, amended down from an original charge of driving while under the intoxicants. Have you gone over the plea form with your attorney?
Yes.
And if you had any questions about to enter a plea of guilty to a criminal charge, was your question answered?
Yes, my questions were answered.
If I accept the plea, you give up the rights contained in the plea form, no trial, no appeal, simply a sentencing, which, given the fact that this is a gross misdemeanor, could be up to 364 days in jail and or a $5,000 fine. You realize that?
Yes.
Then as to 1 count of reckless driving alleged to have occurred within the city of Yelm on September 23rd, 2021, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, I have.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. I see that the recommended sentence is 364 days, but all suspended on some conditions. The most important one would be law-abiding behavior, especially when it comes to drinking and driving. The other one is to obtain a drug and alcohol evaluation and at least attend alcohol and drug information school and a victim impact panel. It sounds like you've already done that. And then you need to pay a $750 fine. Mr. Dooley, anything to add to the recommendation?
No, Your Honor, it's a great recommendation and recommend that you follow it if you would.
Ms. Bowden, anything to add?
Your Honor, she has done her eval, her ADIS, her victims panel. She is 66 years old. I believe this was an isolated incident. There was a little fender bender. Insurance has taken care of. She has full insurance. I don't know if a claim was ever made, but she's fully insured. She takes this matter very responsibly. I know she does not enjoy going to court. She's here with her daughter today. She is totally disabled. She hasn't worked in 18 years. And she has been using a walker when she's been coming in, but hopefully this will cause her health to improve rather than decline, having this behind her. I believe the prosecutor is willing to close the case upon receipt of all these 3 documents, which I have, in payment of the $750. They wrote out a check today. They're prepared to pay the $750 today. And we would ask that upon the court receiving all that the case close. She does understand that this does count as a prior, and any sort of reoffense would cause her penalties to go up exponentially. I don't anticipate the court seeing her back again.
The song goes, do you have anything to add to what your attorney just said? You don't have to say anything, but if there's anything you think I should know or want to tell me, now would be the time. Again, you don't have to say anything.
Not that I can think of right off the top of my head.
That's perfectly okay. Your attorney spoke very well on your behalf. I'm going to follow the recommendation. All jail time suspended, 364 days suspended on the condition you have law-abiding behavior, pay a $750 probation fee. And once that fee is paid, we're simply going to close the case and call call it good. I'm hoping this has been a fun experience, and it sounds like it certainly has been, and one that you don't want to repeat and one that won't be repeated. I'm confident of that.
I'm too old for this. I won't be repeating it.
I'm going to simply wish you the best of luck. Your attorneys negotiated an excellent resolution of the matter on your behalf. I want you to take care of yourself and have a great day. Any questions?
No, sir, Your Honor, but thank you for your time.
Thank you for your time. We'll be sending you a copy of the today's paperwork, and we'll send your lawyer, Ms. Bowden, a copy of the paperwork as well. If you have any questions, give her a call and they'll be answered.
And she can mail in a check with the case number on it, correct?
Certainly.
Okay. Thank you very much, Your Honor. Thank you, Mr. Dilly.
Thank you.
Thank you all.
Bye.
Paperwork to Dilly, I guess that is that. We were going to have somebody show up late because their bus was running late, but it's now, they were going to be here in a half hour, but it's now past. Mr. Aberco has indicated that it would be his preference if she does show up to simply have her sign a promise to reappear and reset the matter to next time. If that's okay with, acceptable to you, that's
okay with me.
That's what we'll do.
All right, then. We'll see you in a couple weeks.
Take care. We'll see you then. If we're all still. Oh, we're gonna call a matter, once again, if you identify yourself by name for the record, if you would.
Ayla Cheetah, Ayla Marie Cheetah.
Full name, Ayla Marie Shedak. Shedak, the citation I have alleged in honor about April 11, 2022. You committed the offense of theft in the 3rd degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You have a right to have a lawyer represent you, and I'm going to appoint Mr. Averco to enter a plea on your behalf, and he'll represent you throughout the course of your case. If you're indigent, he'll talk to you about that off record. Mr. Averco, plea.
Thank you, Judge. Just trying to get into there. Yeah, that would stipulate to probable cause, ask the court to enter a not guilty plea.
The plea of not guilty has been entered on your behalf. That preserves your rights. We're going to set the matter for a pretrial. That'll be on May 26th. Hopefully your transportation situation will be a little bit better then. Conditions of release are law-abiding behavior. Stay in touch with your attorney and appear for court as directed. Any questions at all?
No, not.
I'm signing the.
Go ahead and sign right here in the tab.
Everything's electronic these days. I'm signing the order on today's hearing as we speak. Shedak, I want to thank you for appearing. You take care of yourself. A copy of today's order you can get by going to the window outside the courtroom and to the left, and we'll see you back here in your pretrial date. It'll have the date and time on it. So, and hopefully by then your transportation situation will be a little better in hand.
Yeah, hopefully. Thank you.
Hey,
You have a good day.
thank you for appearing. Dan, take care. the no shows.
Record.
First, no show I have is docket number 1, Jack Chenier. Do find probable cause for the issuance to him of a assault and 4-3 domestic violence citation. He's already got a condition of no contact, but 2,500 cash or bond. Next would be Donnie Jean Colvin, a stalking case and find probable cause for the issuance to him of that citation. The 10,000 cash or bond. Based on the probable cause. Next I have is John Herzog, which I sort of have a feeling that he was not going to, I do find probable cause. I've reviewed the PC statement for Malmus 3, Crim Trust 2, Fifth Third, 2,500 cash bond. Next would be Anthony Navarro. I'd say I find probable cause when he was in custody. And if there's not a warrant out for him, 2,500 cash. And then Abigail Tate would be the last one, and that is a already in warrant status case. So I'll just leave the warrant as it is. And then I forgot, we have one more, Gary Woods, U.S. 3rd. Amend to no vol 2 and FTA.